Hey FFLs, we've been swamped with calls and texts but need to get you up to speed regarding NFA quickly. Whether you currently sell suppressors and short-barreled rifles, or have never handled an NFA item, this message is for you. Slow down, take a deep breath, do not change your operating procedures yet. The recent federal court decision in Silencer Shop Foundation versus ATF, consolidated with Jensen versus ATF, is a major and positive development for the firearms industry. Judge James Hendricks ruled that specified NFA registration and advance approval requirements cannot be enforced against the protected plaintiffs and, where applicable, their qualifying members and customers. For untaxed suppressors, short-barreled rifles, short-barreled shotguns, and certain AOWs. The court's 7-day stay has expired. Silencer Shop and Gun Owners of America report completing 2 specially structured suppressor transfers in Texas. Without Form 4473-4 approval or NFA registration, that is significant progress. DOJ still has 60 days from the ruling to file an appeal. Notably, provisions of the Gun Control Act relating to NFA items remain unaffected by the decision. But here is what every FFL must understand. The court did not repeal the entire NFA. It did not issue a universal injunction protecting every dealer, every customer, or every transaction nationwide. ATF, DOJ, and state regulators have not yet issued complete operating instructions explaining how ordinary dealers should implement this decision. We still have serious unanswered questions. How does a dealer prove that the dealership and customer are protected? Does an individual's membership protect a trust, corporation, spouse, trustee, or other person? How should manufacturers, distributors, and dealers handle Forms 2 and 3? How will ATF manage firearms that were never entered into the National Firearms Registration and Transfer Record? What records should dealers retain to defend these transactions during a future ATF inspection? How will unregistered items later be repaired, replaced, inherited, transported interstate, or resold? What position and what risks are you imposing on your customers if you move too fast? Are you ready for possible lawsuits later if you do something you should not? And what happens in states that independently require NFA registration, ATF approval, or impose their own dangerous weapons restrictions? Those are not minor details. They are serious federal, state, licensing, and criminal liability questions. FFL Consultants has discussed this issue with our Firearms General Counsel. The message is the same. Take a deep breath and wait for formal regulatory guidance. Until ATF, DOJ, your state regulator, or qualified firearms counsel provides reliable instructions applicable to your dealership and transaction, continue your established processes. Continue filing the appropriate forms 1, 2, 3, 4, and 5. Do not cancel pending applications. Do not release a suppressor, SBR, SBS, or AOW without the established approval merely because a customer presents a membership card, website article, or social media post. Next, ensure you are maintaining all established background check and record-keeping requirements. This includes all Form 4473, waiting period, and state law mandates. And do not let your customers tell you how to run your business. This is your FFL. You will answer for the transaction during an ATF inspection, investigation, or criminal trace, not the customer pressuring you across the counter. Moving too quickly could jeopardize your license, create major legal expenses, or turn an otherwise lawful customer into a prohibited possessor or potential felon. The good news is that meaningful NFA reform is moving forward. This ruling may become one of the most important firearms industry developments in decades. But the go-forward procedures remain murky, fragmented, and incomplete. FFL Consultants has prepared a comprehensive dealer white paper explaining the ruling, protected and excluded parties, suppressors, SBRs, SBSs, AOWs, state law concerns, pending applications, interstate risks, and what dealers should do right now. Before changing any NFA procedure, visit FFLconsultants.com and download the free white paper. Read it, share it with your managers, NFA employees, and fellow FFLs. Then stay tuned for verified ATF, DOJ, and state guidance. And we'll be discussing this in depth on Monday during our next Ask Us Anything monthly webinar. Register now to attend on our website. Good things are coming. For now, slow down, take a deep breath, and protect your FFL. This is JB with FFL Consultants. Protect your FFL, protect your future.